Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering Disney demands First Amendment right to fire anyone in free speech lawsuit. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. Disney is trying to deal with the Gina Carano lawsuit. Gina Carano sued Disney because they fired her based on her free speech. Disney has said in their motion to dismiss in front of the judge, hey, we've got a right to say what we want to say, and we can't have people saying things we don't want to say. Gina Carano was saying things on social media we don't want said. We don't want people associating Disney and Star Wars with that kind of speech, so we fired her. Well, that's a pretty big admission from Disney, that they fired her because specifically of that speech. So this case is going to be about whether or not Disney had the right to fire her over her free speech because it didn't agree, supposedly, with what the corporate view was. But not just that. It's not just Disney's free speech. Disney was saying, well, you're going to negatively impact Star Wars. People aren't going to want to buy Star Wars merchandise. They're not going to want to watch Star Wars shows. So Disney here makes the argument that they had to fire Gina Carano because if they didn't, she would severely financially damage the Star Wars brand. Right now, the judge has heard the motion, has not ruled on the motion, but the judge is skeptical and has said, hey, I don't completely believe you, Disney. I don't see why this case needs to go away before we get discovery and really see what was behind all of these decisions. Was it really what you're saying now, or was it something else? And Disney isn't the only Hollywood studio trying to make moves, trying to utilize the First Amendment to get rid of the kind of people they don't like. Now, there are employment laws against doing things like this. But Hollywood studios are taking the position that they have a right to free speech. And within their free speech, they don't need to hire creative people to work on their projects who don't share their same views, because they need to shape their creative projects the way they want to send the messages that they want to send. You may remember this case. This case also just happened recently. From Deadline, CBS claims First Amendment allows it to select writers best suited for its programs in discrimination lawsuit response. They discriminated against this white writer who was up for a job, didn't get the job opportunity. They gave it to people who were diverse, who didn't look like him or didn't have the same gender as him. And CBS defends itself by saying, well, we think they would do a better job on writing our creative work. That's a First Amendment expression issue. But as I said when I covered this video, he's one writer. He's not like the writer of the content. So his contribution would, of course, be diluted by everyone else there. It's not like he's got this vision that's not diverse and it would destroy the value of their property. But CBS isn't even making a financial claim as much as they're making a claim that they have a constitutional right to say what they want to say, and with the employees that they select that they think can say their message the way they want it said. So CBS is not claiming a potential financial loss by a negative association. They're just saying they think this guy's too white to do the job and they don't want what he has to say. So they shouldn't have to hire him. From The Hollywood Reporter, Mandalorian firing lawsuit. How Gina Carano's team and Disney are battling in court. At a Wednesday hearing, a judge expressed skepticism that the Carano lawsuit should be tossed before discovery is allowed to take place. And discovery is when they find out what the other party was saying and doing while the decisions were being made, so they can kind of get the background in front of the judge, and the judge can decide if laws were broken, or the judge can decide if there was a financial claim that should be honored. A federal judge has signaled that Gina Carano's lawsuit against Disney and Lucasfilm over her termination from The Mandalorian will be allowed to proceed as the court considers whether the First Amendment allows private companies to sever ties with employees who publicly clash with their values. So incredibly, this whole lawsuit really was about limiting Gina Carano's free speech. Disney didn't like her opinions. They didn't like what she had to say. They don't agree with her politics. So they fired her. Do they have a legal right to do that, or don't they? U.S. District Judge Sherilyn Peace Garnett on Wednesday pushed back on arguments from Disney lawyer Daniel Petrocelli, who argued the lawsuit should be dismissed because the company has the right not to associate with a high-profile performer on a high-profile show who's imbuing the Star Wars series with views it disagrees with that could turn fans away from the show. Petrocelli urged the court to find in favor of Disney on its First Amendment defense on dismissal rather than at a later stage of litigation after discovery takes place, in which it's determined whether the case should be allowed to proceed to trial. Petrocelli is the same lawyer that defended Disney against Scarlett Johansson's lawsuit. Do you remember this one from Daily Mail? Disney lawyer says Scarlett Johansson's $50 million Black Widow lawsuit is a highly orchestrated PR stunt designed to get us to write a check, and says the written contract is as clear as a bell. This lawsuit was ultimately settled with Scarlett Johansson. But the Scarlett Johansson issue with attorney Petrocelli was going on at the same time Disney decided to fire Gina Carano, and that comes up in a moment. Petrocelli is also the same lawyer that represented President Donald Trump before he got into office in his first term. He represented President Trump in the Trump University lawsuit. Why Donald Trump turned to this Hollywood lawyer to defend Trump University. Daniel Petrocelli, who made his name in the O.J. Simpson civil trial, so yes, this guy even represented O.J., and has repped everyone from Disney to Keisha, is defending the GOP frontrunner in a case headed to trial just as the election heats up. Trump is always getting sued for something. But this guy Petrocelli is everywhere. Quote, "I'm not convinced there are no disputed facts," Judge Garnett responded. She pointed to allegations that Carano was terminated to deflect attention from Disney's contentious business decisions at the time, including the company's contract dispute with Scarlett Johansson and criticism of Florida's parental rights and education law, which led to the dissolution of its special tax district in the state. And we covered that issue with the special tax district that Disney used to have in Florida. They completely blew it going up against the government. No, you can't just take on the government of a state that has the backing of its legislature. And no, you're never going to get special rights in a state as a private company that are not subject to being removed by the state that gave you those rights. It's the state that has the authority. In any case, Disney lost that, and now they're on to this case. The lawsuit revolves around allegations from Carano that she was wrongfully terminated and discriminated against when she was booted from the series for voicing right-wing opinions on social media. And that's why Elon Musk is backing her lawsuit. It was her comments on Twitter that got her fired. Gina Carano appeared in the first 2 seasons of The Mandalorian. She wasn't under contract to appear on the 3rd season or any other Disney production, according to court filings. Carano sued after Lucasfilm in 2021 announced that she wouldn't be returning to the series after sharing a post in which she said, quote, "Most people don't realize that to get to the point where soldiers could easily round up thousands of Jews, the government first made their own neighbors hate them simply for being Jews." The post continued, quote, "How is that any different from hating someone for their political views?" She advanced claims that Disney violated California labor laws prohibiting employers from directing workers' political activity and reprimanding employees on the basis of political speech. Carano's defense for being fired is not just her free speech rights, her First Amendment rights, which she does actually have. It's also California labor laws, and states do have laws protecting employees that stop employers from doing exactly what Disney did. At Wednesday's hearing, Gene Scherer, a lawyer for the actress, stressed that the comments at issue in the case were made from Carano's personal social media accounts. Quote, "Nothing she said was on the show or on set," he said, as Carano sat at the defense table in the courtroom. However, that may not matter, at least not according to Disney. The company claimed that there are broad liberties afforded to private speakers and what viewpoints they choose and don't choose to express. In a case dealing with free speech rights, the Supreme Court held the organizer's decision to exclude a message it did not like fell within its right as a private speaker to shape its expression by speaking on one subject by remaining silent, the court found. But when you're creating a parade, the parade is the message. This isn't about people that participate in the parade, what they're doing outside of the parade. Disney's situation is twofold. They're saying, hey, look, she can't even be a member of the parade. We don't care about what she's saying and doing inside the parade. We don't have any problem with that. She's on board with us with that. We have a problem about what she does when she's not in that parade. And she's prominent enough that she's coloring the entire parade. Or she potentially could color that entire parade. And as a result, their second issue, she's causing us financial damages. She's damaging the Star Wars brand, as you've seen from The Acolyte and as you've seen from other versions of what Disney has done with Star Wars. They've damaged the brand a lot on their own. There's nothing Gina Carano could do. And when I say nothing, I mean literally nothing to damage the Star Wars brand anywhere near what Disney has already done to Star Wars. If nothing else, it would improve the brand because Gina Carano is known as a conservative professional. If she were involved with the Star Wars brand, sure, some normal people and conservatives like me and probably you would watch Disney shows more often, at least just to see Gina Carano when she pops on sometimes. Disney argued in court there's a First Amendment right to choose employees who properly convey their values, even when those choices would otherwise violate state anti-discrimination laws. Disney went on to cite the Supreme Court in Boy Scouts of America versus Dale, finding that the organization's decision to fire an openly gay assistant scoutmaster is protected under the Constitution. That constitutional right, the court concluded, shields the Scouts from violations of New Jersey discrimination laws. Here's that case. In the U.S. Supreme Court, what did the Supreme Court's decision in Boy Scouts of America versus Dale rule about the right of association? The court held that applying New Jersey's public accommodations law to require the Boy Scouts to admit Dale violates the Boy Scouts' First Amendment right of expressive association. In effect, the ruling gives the Boy Scouts of America a constitutional right to bar homosexuals from serving as troop leaders. So Disney is using as a defense the constitutional right for them to bar homosexuals, heterosexuals, whoever they want to bar as a class from participating in Disney projects. The fact that Disney is so pro-LGBT and they're utilizing this precedent to try to back them up shows their situation is a little bit strange over there. Because if this gets more media coverage, you'd imagine that could damage Disney. They're very supportive of the rainbow flag during Pride Month, but they'll go against it to use a precedent that can help them in court. But what would this say about the future if Disney really did have the right to say, look, our First Amendment association rights allow us to not want to associate with people that have political views that are different from us? You would think to save time, they would ask people about their political views when they're hiring them. Why wouldn't they? It would save them a lot of time and trouble. Or they would do political dossiers on people before they agreed to hire them. I can't see how the court could allow this to happen. Under those two cases, Disney said that the state can't force employers engaged in expressive activity, in Disney's case, movies and TV shows, to convey its message through speakers like Carano, who allegedly impair its ability to properly exercise its values, which it said include respect, integrity, and inclusion. I know we have redefined inclusion to try to keep the communists happy, but how is it inclusive to have only one set of political views in any of your creative expressions? Doesn't sound inclusive. The First Amendment, Disney claims, entitles it to protect its speech in the Star Wars series from association with views that it and many viewers considered offensive and contrary to its message. Quote, the messenger is part of the message, Petrocelli said. He then proposed, quote, imagine she made comments that she hates Jews or that there was no Jews dying during World War II. To compare conservative speech or even liberal speech or any group of speech to comments that are obviously considered generally offensive really doesn't make sense. I don't know how a judge would get convinced with an argument like that. She never said anything like that. So to ask the judge to consider a hypothetical like that has nothing to do with her case or her situation. Yes, the case was about speech. And no, she never said anything like that. Tens of millions of people agree with Gina Carano's points of view. It's not like these aren't mainstream views that we need to be careful about totalitarianism in the United States. That's what Gina Carano was saying. In response to Disney's focus on the Supreme Court's ruling in Dale, with the gay Boy Scout leader, Cher said that free speech rights can't be used as a shield against violations of discrimination laws and that the ruling in the case was based on a fully developed factual record, not at the motion to dismiss stage. Which is a great point. Have a factual record. Get the facts out. Let's see if Disney's claim is even relevant. Let's see if it had nothing to do with the Scarlett Johansson issue or other controversies going on inside of Disney. He underscored, Disney's First Amendment defense cannot allow it to short-circuit the normal litigation process. Discovery will reveal whether the company violated state civil rights laws when it terminated Carano, he added. Quote, I don't necessarily disagree with you, Garnett replied. Carano's backers include Elon Musk, who's helping fund the lawsuit through Twitter. Musk said he would foot the legal bill for users who claim they had been discriminated against due to their activity on Twitter. I hope we start to see more coverage from people that actually are constitutional attorneys and really do understand the issues, because this is where diversity, equity, and inclusion is going. Now they're on the defense. The first major Hollywood lawsuit was against CBS for discriminating against the white writer who CBS said doesn't think they have the right skin color to work on one of their projects. The next major lawsuit now is with an even bigger company, Disney. And this is a pretty high-profile lawsuit. Disney is now openly making the claim that they have a First Amendment right to fire anyone they want to fire who they think might negatively affect their image or go against the views that Disney as a company has. It's like literally the opposite of affirmative action. Merit-based hiring is not the opposite of affirmative action. The opposite of affirmative action is not hiring a group of people who look or think a certain way that you would classify as an entire category. And that's what Disney is saying in their motion to dismiss right in this lawsuit right now in court. This can't be allowed to stand. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.